your weekly show that covers a wide range of business-related issues, which includes market trends, economic developments, as well as analysis from experts. In studio today, we are joined by Stanbic Bank Botswana Data Protection Officer, Boitumelo Motshobedi. Motshobedi, welcome to the studio.
Thank you for having me.
Emma, briefly introduce yourself to our viewers at home.
Oh, thank you so much. As you already mentioned, my name is Boitumelo Motshobedi, and I'm currently serving as a data protection officer at Stanbic Bank Botswana. In terms of my background, I'm a lawyer by profession, and I served as an in-house attorney for 8 years, and subsequent to that, I became a DPO.
Emma. So, the data protection.
So, with the Data Protection Act, you know, when you're an in-house attorney, you are tasked with having to interpret the law for your colleagues, for management. So, in 2021, that's when they published the 2018 Act, and that's when I came into contact with the law. We engaged a consultant to come and help us in terms of complying with the Act during the transitional period. So during all those transitional periods, I've been getting more insight of what is required from the Act and familiarizing myself with the requirements of the Act.
Okay, Emma. So let's talk more about the Data Protection Act and what it essentially prescribes.
So the Data Protection Act is important to also consider the past and the history of the Act. So the data protection law, they have their roots in privacy. Privacy, we're talking about the fundamental right as enshrined in the Constitution of Botswana under Section 9. So because we evolve, and initially this privacy law was more focused on the physical privacy. So there was a need for us now to consider data, because that's something that is also personal. Ultimately, as Botswana, we had to respond to that call, and the Data Protection Act of 2018, that was our response to the need. The 2018 Act was repealed by the 2024 Act. So our Act actually has its roots, or it was essentially intended to copy the GDPR, which is the General Data Protection Regulations, and this is the law for the EU. So as Botswana, we copied our principles and the rights, and ultimately we're just trying to mirror the GDPR. This is the global standard. It sets the tone for data protection globally. So with the 2024 Act, I think they identified a lot of gaps in the 2018 Act. So as a way to fill those gaps, we had to address a lot of issues. For example, the rights. With the 2018 Act, it didn't cover all the rights. And with the 2024, they had to extend all the rights as outlined in the GDPR.
Okay, so which sectors of consumers are covered by the Act?
The beautiful feature that I can say about this particular Act is that it's not sector specific. It doesn't apply to companies that operate under a certain industry, but it covers all companies. So what you need to know ultimately is the key players or stakeholders within the Act. We're talking about the data controller, the data processor, as well as the data subject. So those are the key stakeholders in terms of the law, this particular legislation. So by virtue of you operating your business here in Botswana and processing personal data that belongs to Botswana, you are expected to comply with this particular legislation. It's not for a specific industry, health or telecoms or banking, but it covers everyone for as long as you fit that description, either a data controller or a processor or a data subject. Now, if I'm to break down the definitions, a data controller, we are referring to an entity that considers the means and purpose of processing personal data. For example, these are government entities that collect personal data, and they determine the use and purpose of us collecting that personal data. And then we have the data processor. So a data processor is that company that processes personal data on behalf of the data controller. And normally they act on instructions from the data controller. And then we have data subject, that is you and I, the owner of the personal data that is being processed. Your name and your address and the likes. Because it belongs to you, you are the data subject.
Emma. So we're going for a quick commercial break. With Motshobedi. Motshobedi, before we went for the break, you were talking about the sectors of consumers covered by the Act.
Yes, definitely. So I spoke about the key players in the data protection ecosystem. That is the data controller, the data processor, as well as the data subject. So ultimately, it's important for us as entities to determine our role, whether based on the agreement or the legal instrument that governs the relationship, whether you are a data controller or you are both data controllers, then it makes you guys joint controllers, or you're a data processor. But as for the data subject, we all know we're all data subjects, so it's an easy one.
Speaking of that, what exactly is personal data in context of Botswana?
So still under personal data, we have a subset called sensitive personal data. The sensitive personal data is that data that requires higher level of protection, and it also requires specific or explicit consent when you're dealing with it. An example of sensitive personal data, we are referring to that information that reveals your health, your race, your ethnicity, and the likes. So the beauty about our law is that it clearly stipulates what forms part of sensitive personal data and what can be regarded as just personal data.
Okay. What obligations does the Act require for the regulated entities?
So obligations are placed on the data processors and data controllers, excluding data subjects, of course. So one of the key things that as entities we have to comply with is the principles. So you have to counter check and see your processes and see if you are aligned with the principles. And the requirement is also that when you're dealing with the principles, you don't get to choose which principle you comply with. You have to make sure that all your processes, you comply with all the principles of data protection. An example will be data minimization, purpose limitations. When you collect data, you have to specify what is the purpose of you collecting that data, and collect only the data that is necessary, that is data minimization, as well as you have to be collected in a fair and transparent manner. You have to disclose to me who are you and why do you need my data. You need to be fair and be transparent. That is the expectation. And another obligation is for organizations to operationalize the data subject rights. So these rights of the data subjects, they are outlined in the Act, right? And as an entity, you are expected to have modalities to allow data subjects to exercise and enjoy their rights in your organization. So ultimately is when you have my data, you have to make sure that you comply with the law. For as long as you are intending to use personal data for commercial purposes, make sure that you are compliant with the requirements of the law.
I like that you mentioned that. Let's go for a quick commercial break. We'll continue our conversation. Conversation with Motshobedi as he shed more light about the newly enacted Lawyer Data Protection Act. So, Motshobedi, businesses have previously said the act, while necessary, is an additional expense. What is your view on these comments?
I can definitely affirm to that. Reason being that there are certain expectations from the law that will require investment. I'll give you an example. You have to operationalize the rights, and like I said, you have to make sure that you enable data subjects to enjoy the rights for as long as you have or you process that personal data. And one of the rights is right to deletion, as well as data portability. So the right to deletion is basically delete all the personal data that you have about me, Boitumelo. Now, you as a company, you have to have in place certain systems to allow for that. And deletion does not always mean pressing like a button, delete. Sometimes other options would be anonymizing the data. That's a form of disposing of data. Anonymization is outside the scope of data protection. So for as long as you keep anonymized data to remove all the aspects that you can use to identify a person, ultimately then it doesn't fall within the realm of data protection. And then there are other options also, the pseudonymization. Pseudonymization is similar to anonymization. However, this one, because I can cover your personal data within information again alone. Just cover it for a certain purpose. Then later beki unmask whatever that I used to cover that information. But because of that process and because it's possible for you to reverse it, it still falls within the realm of data protection. So companies are expected to consider such dispensations and technologies to allow for that. And another example would definitely be for the data portability, where as a data subject, you can walk into an organization where you know they have your personal data and instruct them to transfer your personal data to another data controller. For example, in the banking space will be where you are changing a bank. So I don't want to bank with you anymore. Because you have my information, instead of me giving my information, I would just instruct you to say, look, you have my information, just transfer it to the other data controller. And then you have to comply. And you are expected to comply or to facilitate the rights within 30 days. That is the statutory timeline. So I think businesses would definitely have a challenge in terms of deleting data that they have from the past. And I think maybe it also leads to the conversation of, are we saying then the law applies retrospectively? For Botswana, definitely they would think it applies that way, but legally it doesn't. The only reason why we say it may sound as if it's retrospective is because data yelos onalione ka nna ele ya 1992 ele. I can always come into your organization to say, because I gave you my personal data ka 1992, can I have it back? As me exercising my right to access, I would want to access it, and definitely maybe I can actually even request for a copy. So you cannot even say or give me excuses for the system and all that. You have to be accountable. And I think ultimately it explains why all this time we've been having this period, this statutory period or time frame that was granted by the commissioner and office of the president to say, we're going to give you a transitional period, which is a grace period for you to align, and fix your affairs for you to be compliant. So I agree. It's definitely going to cost companies a lot. And another aspect that I think is going to come at a price would definitely be privacy by design, where companies will be expected to consider data protection aspects throughout the life cycle of the technologies and solutions. And because we are all going digital, the expectation is for you to secure people's data. I get into the system or your application and I'm putting in my personal data. I expect you to have proper safeguards and technical as well as organizational safeguards in place to protect my data, and also consider the CIA, which is the confidentiality, integrity, as well as availability of data. So ultimately, it goes back again to the principles. You have to comply with the principles of data protection. Okay. And I think for most people, it will be easy if you use those principles as a checklist in all your processes. Have I covered this? Have I covered this in all your processes? It makes it easy. Okay. You know, and most of the breaches, sorry, most of the breaches, I'm just thinking, most of the breaches would definitely occur at a functional level. And I think it's important for organizations to also consider doing a ROPA, what is called a ROPA. This is records of processing activities. It gives you that view or line of sight and visibility of all the personal data that you process as an entity. So you also identify your collection points and see what can I put in place there to automate the process, and what can I do to safeguard the information that I collect as an organization, and ultimately also to check against information that is really not necessary. I mean, we still have companies that are asking for our addresses, physical addresses. The question is, are you going to send me anything through post? If not, then why are you processing it?
Okay. Speaking of which, in which instances does a consumer have a right to walk and say, hey, delete my information?
Yes, so the law actually has all the rights outlined in the Act, right? So what I want for data subjects is to familiarize themselves or just make it a habit or a culture. When you walk into an entity, look out for what we call a privacy notice. A privacy notice communicates to you as the data subject to say, we are this particular entity, we are a bank, as a mamang, we are going to process your personal data. For example, you walk into an entity by CCTV. That's a form of collection. That's a form of processing data. So before you even enter the building, the expectation is for you to have a privacy notice that will tell you you're about to walk into this building, but know we are going to process your personal data. This specific personal data that in relation to CCTV will definitely be footage. We're going to collect your footage, and the reason why we're doing this is because of security purposes, an example, and we're going to keep it for this period. And as an entity, you just have to go through section 39 to see if you are covered all the aspects of a privacy notice or provisions of a privacy notice. And once you've satisfied yourself, you as a data subject, you have to see whether the data subject rights that are availed for that particular exercise, for example, the CCTV, do I have the option to come in and request for deletion?
Okay. Yeah. In which sections of the obligations under the Act do you foresee businesses having difficulties in complying?
I would definitely say the new section that came with the 2024 Act after repealing the 2018 Act. One of the changes were in relation to data. Data residency I think is going to be a challenge for us, because with the 2018 Act, it restricted data to cross the border, ultimately, so altogether. But with the 2024 Act, I think the Act is more lenient to say you can transfer data outside the country, provided you do keep copies of all the personal data that you process outside the country. So I think it's going to be a challenge for most companies, especially those with international presence, for you to say, how do I make a copy of all the personal data that I have sitting elsewhere? Remember, these systems people have been using for many years, and they've been processing those data outside. And many organizations, they do use cloud services, and we all know that the data server is probably located somewhere else outside Botswana. So now you have to comply with all the conditions outlined in the Act in terms of processing cross-border information, as well as also keeping copy as required by the law. I think ultimately that will be the most difficult.
Okay. So what penalties does the Act impose on non-compliance, and how can businesses ensure that they remain compliant?
The penalties are outlined in the Act. The highest fine is 50 million in terms of the 2024 Act, and the lowest being 1 million. And because of that significant change, the expectation is for companies to try by all means to be compliant, do more assessments of their processing activities. That is to conduct what is called a DPIA, where they find themselves processing high risk or rather conducting high risk activities or dealing with sensitive personal data, and also appointing DPOs where necessary. The law does provide for, it gives guidance in terms of the entities that can appoint DPOs, and companies should now invest in training their employees, because compliance is not only at a managerial position or level, but it needs the entire organization. So the expectation is for them to do enterprise-wide trainings.
Okay. Any last words?
Last words would definitely be, compliance is a legal obligation, but it's important for organizations to demonstrate trust. And to build trust with your customers, you need to also take an active step. And the expectation is for you to be compliant altogether. And building trust with your companies, you need to make sure that you are also aware of their rights, and you are accountable as an organization.
Okay. Thank you so much, Motshobedi, for coming to our studio.
Thank you for having me.
We've learned so much about data protection.
I'm glad.
Emma. From me and my team, until next time.